Yes, there we go.
Yeah. Just whatever.
There, perfect. Okay.
We don't want to take.
Georgette is handing out my articles. They're very good. I have trouble sleeping at night. Read 2 articles. But as well, there's a drafts of powers of attorney and healthcare properties. And those are the 2 documents that I always tell everybody that everybody should have. Healthcare property is a very simple form. We can get to it towards the end. The power of attorney is a lot more involved, and we're going to go into detail. But the subject today is elder law, broad generalization. But that covers a lot of things. It covers Medicare and Medicaid and long-term insurance. And I always start out by telling people that if you have significant assets, if you're comfortable, all right, everybody's different. I'm very good at helping people spend their money, you know, so I healthcare problem, yeah. If you're in good health and you can afford it, you're best off avoiding elder law attorney and looking towards long-term insurance. And people say, oh, I have insurance. I have supplemental insurance. It covers the gaps in my Medicare coverage. But that's limited, all right? What I'm talking about is long-term catastrophic insurance that will cover you should you need either extensive care at home, assisted living care, or nursing home care. Those things are very expensive now, and they're getting more expensive. Nursing homes on Long Island are averaging $15,000 a month. People hear that. I go back and forth to Honduras where my wife is, and they think, you know, $15,000 a year, and it's like, no, it's a month, and it's hard for people to comprehend that kind of number. Assisted living, much nicer than nursing home if you are at that level. Still, you know, $5,000, $6,000, $7,000 a month. Home care, $20 an hour. Weekends, $25 an hour. If you need 24-hour care, you go through money very quickly. And so I always tell people, now the problem with long-term insurance, it's a very good thing. The problem with it is if you have a pre-existing condition, they don't want to know you, because they don't really want to pay it out, the insurance companies. They only really want healthy people, okay? So if you have a pre-existing condition, you're not going to be covered. And it's expensive. It can be very expensive. But when I have clients come into me, in their 70s or 80s or so, and they're in good health, and I see that they have a total estate, you know, hundreds of thousands, $1 million or so forth, I very often will say, the first thing I'll say to them is, you know, you might want to consider, rather than talking about moving assets out of your name, giving up control, so forth, you might want to think about buying this long-term insurance. And I'm always surprised. I can't tell you how many times people have said to me, nah, I don't want to be bought, too expensive. And yes, it is expensive. You may, you know, for a couple in good health, late 70s, early 80s, you may be talking about $10,000 a year. And people just don't want to spend it. But when you think about what it covers, it really is a good thing. And like I thought, the best way I could put it is you end up avoiding attorneys like me. And giving up control at some point down the line. But I'm always surprised at how many people just object to the idea. But it's something to consider. I've had a difficult time over the years finding long-term insurance salesmen who are straightforward and, you know, and not annoying. But I think I've finally found a few. And, but, you know, you have to explore. You know, you get things in the mail, you get recommendations. And you talk to these people. You try and find one who isn't going to call you every day and say, did you decide yet? Did you decide yet? Did you decide yet? But really, long-term insurance is something to give careful weight to if you don't have pre-existing conditions. And again, that's the problem with long-term insurance. If you do have pre-existing conditions, or if it's just too expensive, or you just don't want to spend it, you just don't like the idea of laying out that kind of money every year, then you have to look towards elder law. And a lot of times people will say, oh, well, again, like as I mentioned, I have Medicare, and I have a supplemental policy, so I'm good. But that's not the case. Medicare coverage is limited. When it first went into effect, it was a short-term program. People objected to it strenuously, much like people objected to Social Security in the 30s, people objected to Medicare in the 60s, and now we're hearing objections to Obamacare. Okay, it's the same thing. The idea with Medicare is, it was passed in 1965. It was for people who were over 65. And, we look back and we say, oh, things are getting better. In 1965, people didn't live that much longer past 65. We made tremendous strides, okay? But it was a short-term plan, and it still is. So it will cover up to 20 hours a week of care at home, all right? It will cover up to 100 days in a nursing home. And it has conditions. It's not based on your finances, it's based on the level of care. You have to show a certain level of care to be eligible for Medicare coverage. So if you're in a nursing home, you have to have come from at least a 3-day hospital stay, and you have to be getting skilled care on a daily basis. Okay, that means therapy. It means either somewhat of a skilled nature coming to treat you on a daily basis during that time. So that 100 days is not automatic. On day 21 or day 37 or day 58, you can get a notice from the nursing home saying your Medicare is being discontinued because we don't think your level of care is skilled anymore. And they'll make that decision much quicker than, in fact, your level of care has been reduced. Same thing at home. You come out of the hospital, you get some Medicare coverage at home, but there has to be some skilled care, treating a wound or some kind of observation of how you're doing, some kind of therapy. And the coverage has holes in it. Medicare, for the first 100 days, they'll pay the first 20 days in full. The next 80 days, there's almost $150 a day co-insurance payment that you're responsible for, if they will even cover you. A lot of people have, ARP, Blue Cross Blue Shield, Medigap policies that will pay that. But even if you get the full 100 days, if you're there longer than 100 days, you're on your own. And if you need more than 20 hours a week of care at home, the coverage, sometimes they will supplement it, but for a limited period of time, and then you're on your own. And that's a problem, okay? Now, again, you've got to be careful. You listen to the insurance guys, and they'll tell you, well, statistically, everybody in this room is going to go to a nursing home. When I started doing this 1,000 years ago, people went to the nursing home and that was it, you were done. If somebody ended up in a nursing home, they stayed in the nursing home until they died, and that was it. That's not the case anymore. So a lot of times people go to the nursing home now for rehabilitation. You get better rehabilitation in a nursing home than you might in a hospital. If you have a broken hip or a stroke or something, you go there and you'll be out within the 100 days and you're okay. But the idea really of elder law is to hopefully plan ahead of time, but certainly to have some structure. What happens if I or a loved one are going to need long-term care, either at home health care, but like 24 hours a day, 7 days a week, or in a nursing home, okay? And the mid-stage, we have in the middle of that is assisted living, but assisted living is not covered, for the most part, is not covered by Medicaid, but the Medicaid program will cover home health care and nursing home care. And the big problem, big mistake people make, not so much now as in the past, but people say, well, I'm a middle-class person, I have assets, Medicaid is for poor people, I will never be eligible, so I'm not even going to think about it. And what people don't realize is, at $15,000 a month, you can go from being middle class to poor very quickly. And that's what the Department of Social Services would like. What they would truly like is for people to spend down all of their assets and die. That's right, and don't bother them, make it convenient for them. And so you'll hear this expression all the time, spend down. And I like to tell people, if you hear the term spend down, the person that's using it is either intentionally or unintentionally misleading you. because that's not the way, you know, that's not what you need the planning for. You know, anybody can spend down your money and then go on Medicaid or die. But the idea is to do some planning, precautionary planning ahead of time. And the way, you know, there are certain fundamentals with Medicaid that you should be aware of. First, home care, community Medicaid. There are two types of Medicaid. There's community Medicaid and there's institutional Medicaid. Institutional is the nursing home, period. It's not the hospital. Hospital is still considered community, okay? Community Medicaid, aides coming into the house to be of assistance, as much as 24 hours a day. There are no penalties for transferring your assets. There is a look back and there's a penalty. And if you leave with nothing else today, I hope you leave with that understanding. There is a difference. People always confuse them. Oh, the Medicaid look back and the Medicaid penalty. The look back is, we see that today you have $14,400 or less. That's the number that you're allowed for Medicaid. We want to know, what have you given away in the last 60 months, okay? For community Medicaid, the ideal answer to that question is, I tell people all the time, I've been saying it for 25 years. The ideal answer is, yesterday I gave my beloved attorney, John Bigler, $1 million. No one's ever done that, but I keep throwing it out there. You never know. I might get one.
You have to do that.
Yeah, but I'll take care of it. That's all. The idea is you can give all your money away to anybody. The mailman, the teacher, the executive director.
No, I couldn't even accept it, it'd have to go to the center.
And you can give all your money, I mean, and realistically to family members or to people that are close to you that you trust. You shouldn't be giving your money to lawyers, that's the problem, okay? But you can give all your money to anybody and there is no period of ineligibility for home care. You have a question?
Yes, I did, I missed a word, you said for Medicaid, you either have a look back,
There's a look back
and what's the other?
and there's a penalty. In other words, look back is tell us what a curiosity period. We want to know what you've done in the last 5 years. And then there is now that we see what you've done, we are going to, in the appropriate situations, when we can, we're going to attach a penalty. We're going to have a period of time where we wash our hands of you, where we say, oh, because you gave money away, we're not going to give you Medicaid coverage. But that doesn't apply for community Medicaid. There are no penalties. So, you know, what have you given away in the last 60 months? Yesterday I gave my son, my daughter, my husband, whatever, you know, all my assets, and you will be immediately eligible for aides to come into the house. All right? Sounds almost too good to be true, but it's been that way since 1989. Quick history lesson. You're not going to believe this. But in 1988, Medicaid, Congress revamped the Medicaid law. And they made a mistake. I know you, Congress made a mistake? How could that be? Yeah, but they did, a big one, all right? They got so caught up in nursing home Medicaid, they forgot about home care. Completely forgot about it. And so they repealed the old law that had penalties for home care and put in this new law that never mentioned anything about it. And they accidentally repealed penalties for home care. We used to have it 2 years or more, all right? In most states, it wasn't a big deal because most states don't have much to offer in the way of home care. You'd be surprised. Florida, where there's a large senior population, not very good as far as home care. New York State has, as much as we as attorneys complain, this is a good state to, you know, for practicing elder law because we can have people get 24-hour a day, 7-day-a-week care, assuming you medically need it. But the people that make those determinations are pretty liberal, and so it's not unusual to get 24-hour care. And there are no transfer penalties for transferring your assets to make yourself eligible, right? So again, I mean, and the numbers are in the folder, so don't worry about the numbers so much. But you're allowed, in New York State, in 2013, you're allowed to have $14,400 in resources.
Is that for an individual?
For an individual. For a couple, it's $20,100. Now, that does not include certain things. It doesn't, that doesn't include your home.
Right.
That's an exempt asset. And it doesn't include qualified plans that are in payment status. So I've had people have an IRA for $500,000. They're on Medicaid, okay? Medicaid will count the income, the distribution that they have to take, but the principal is exempt and will go to beneficiary on the death of that person.
And there's no lien put on the principal?
There's no lien on the principal of the qualified plan, but lien, that's a good point, but Medicaid is sneaky when it comes to your home.
There's a lien on the home.
And what they'll tell you, the home is sacred, it's exempt, don't worry about it while you're alive. But on your death, and the death of a spouse or minor disabled children, then, as I said, then your family finds out there was another child you never told them about, the Nassau County Department of Social Services. And they come in and say, oh, wait a minute, we laid out on your $500,000 home, we laid out between husband and wife, $498,921.13. So we have a lien for that amount. And you kids, you get the rest, all right? So a big part of Medicaid planning is to, especially on Long Island, is to protect the home, critical.
Is that like in the city also?
Yes, I
Same
talk,
thing?
the city, a lot of people have co-ops, so, we're dealing, but yes, the city, anywhere, your home is exempt while you're alive. And not only while you're alive, but while it is your home. There's another sneaky thing that they will try at times, and the city is famous for it. If you are in a nursing home for 6 months or so, and the medical evidence looks like you're going to stay there, Medicaid can come forward, even though you're already qualified, and say, you know what, that place that you called your home, that's not your home anymore, because your home is in the nursing home. So we are taking you off Medicaid. We're removing that exemption on that house, and we're saying you just own a piece of property, and so, too bad for you, you're off Medicaid. So there are significant reasons for looking to protect the home. And one of the things we do for people who come in early, and it's precautionary, I try and be conservative. I may be a flaming leftist liberal, but as far as planning, it's a conservative thing. If people come in and in relatively good health, we may look to do something to protect the house. I want you to hold on to your liquid assets. And as I'll get into as we go along, we can protect the house and you can still have a level of control. Okay? But I'm jumping ahead. As far as staying with community Medicaid, all right? Again, you can make yourself eligible by transferring all of your assets down to the $14,400. You'll keep your IRAs and qualified plans and so forth. But you'll transfer, the other things, assuming you have people that you're comfortable with that are going to hold these assets on your behalf, and that's critical. You've got to be careful with that. And, we're going to talk about possibly putting some assets into a trust, but there's going to be a certain amount of money that you're going to need to have confidence in other people to transfer to hold for you, to use, that you feel comfortable that those people are going to use it on your behalf, all right? So, you transfer your money, you make yourself eligible, you get whatever hours you need, 24 hours, 7 days a week, all right? And now Medicaid looks at your income, and they say, okay, we are going to allow you each month of your monthly income, we are going to allow you, oh, thank you, ooh, isn't she nice? Yes, that's great, thank you. I've been standing up for an hour. I had gallbladder.
You can sit down and talk to us, John.
No, I'm good. I feel good. If I start to waver, I'll sit down.
You
Then the camera. But Medicaid allows you $820 a month of income if you're in the community. All right. If you have more, that does not make you ineligible. You will never be denied. Sometimes people call me up and say, oh, I got denied Medicaid at home because I have too much income. That can't happen. What Medicaid says, oh, you have $1,820 a month? You have $1,000 too much. You're approved, but you have to spend $1,000 of your income each month on medical expenses. Okay, not on anything silly, like food or taxes or homeowners insurance, luxuries, things like that. Only on medical expenses. That $820 is for, you know, for your fund money, for your food and your taxes and so forth. Buy a shirt or something. But $820, and in the past, more than 10 years ago, people would say, you know, go to the city and say, but my rent is $900. How am I supposed to live? And the Medicaid workers always had the same very succinct answer. Don't really care. And if you don't live, I can close your file, go back to reading the paper. All right? But about 10 years ago, we got a gift that the state allows now. And it has a fancy name, but it's not that fancy. It's called a charitable pooled income trust. It's one of the few no-brainers in elder law. A lot of times with elder law, it's like, you might do this, you could do that, you might do this. If you are on community Medicaid and you have significantly more than $820, you are always going to want to set up a charitable pooled income trust. What does it mean? Let's say that person with the $1,820. Ordinarily, in the past, they would have had to basically flush $1,000 down the toilet every month. You know, spend it and contribute it to the home health agency. Now, we can send it to a charity. You say, oh, big deal for the charity. Say, no, the charity charges an upfront fee, a couple of $200, and then depending on how much you're giving them each month, they'll charge a monthly maintenance amount. You know, it might be $40, $50, $60. But the rest of that money, let's say $950 that they're holding for you each month, you can then send them any of your bills for food, or taxes, or homeowners insurance, or trip around the world, or fur coat, or anything you want. And the charity will pay your expenses out of that money they're holding. And it's wonderful. Because in the past, you know, I would have a retired teacher. They have like very little assets, but, you know, $3,000, $4,000 a month of income. And I would have to tell them, it doesn't pay for you to apply for home health care because you have to, you know, flush all the thousands of dollars down the toilet every month. You're better off, and I said, well, you're better off going out and hiring a legal alien. And that's what people did. But now, we can send that money to the charitable trust and have them use that money for the individual or spouse, you know, every month for expenses. Now, yes?
Is that handled by a bank or is that handled?
It's handled by the charity. That's why they charge that maintenance fee every month.
Any charity?
No, there are certain charities that do. There are more and more. For the last 10 years, I've used the same one. New York State Association for Retarded Children, NYSARC, because they've had it set up. They're very organized. They pay the bill. You send them the bill. They pay the bill. And you know, it's like, I'm not going to change. You know, it's a good thing. Why, you know?
If it ain't broke, don't fix it.
Exactly. There are others, though. There's a Jewish one. A friend of mine who's an elder law attorney had a disabled child who passed away. He set up a charity, and he's running it now, making a lot of money. But I'm happy with NYSARC. But there are different charities that do this. But it has to be one of the charities that sets up these charitable trusts that has the staff to administer it. Okay. But it's a very effective way, so that between the fact that there's no penalties for community care and the charitable trust, there's I always try to encourage people, look, if you can stay at home, you know, obviously that's the best place, that's the healthiest place for you to be. And because we have significant, you know, community Medicaid services, and we have the charitable trust, there's a better chance, I think, you know, in New York to be able to stay at home. You know, unless it gets to the point where, you know, what happens, you'll see, you know, the aide, you have an aide for a few years who leaves, and then you have one for a few months who can't take it anymore, and then you have one for a week, and then you know that person probably needs to go to a, you know, more structured facility. And then we can look at assisted living, but there are a few assisted living facilities that take Medicaid, but for the most part, they're private pay, and then we look at the institution in the worst case scenario. Now, nursing home Medicaid, the institution, that's a lot different, it's more complicated, but the thing to keep in mind is even in the nursing home scenario, something happens. The worst case scenario, the worst thing that should happen for anybody, it's not great, but the worst thing is to lose half of your assets. So I constantly hear people go, oh, I know such and such a family, they lost every penny. That should never happen. The worst thing if someone needs a nursing home, even if they've done no planning ahead of time, is to lose half. Now, in the nursing home scenario, there are penalties for transferring assets. All right? And basically, on Long Island, for every 12,000 or so that you transfer, you're ineligible for 1 month in a nursing home. There are exceptions, and I'll go into them once I explain the mechanics of it, but there are some exceptions. Bottom line, though, is that the law changed in 2006. The law changed horribly. It used to be prior to that, if you transferred $120,000 today, November, all right, the penalty would start in December, even though you were home. And so $120,000, you were ineligible for 10 months. All right, you may 6 months into that transfer fall or break something, you need to go to the nursing home. Well, but you already got 6 months of the penalty that's being eaten up. It's good. All right? And in the worst case scenario, back in the old days, prior to February 2006, we could immediately save half the money. You know, it was nice for me to be able to say to people, you know, don't panic. You don't have to, just because you're getting older, it doesn't mean you have to give all your money away. Understand that if something happens unexpected and you need to go to a nursing home, we can still save half. We had our rule of halves. If you had $240,000 and you tripped and fell and needed to go to a nursing home, we could immediately transfer half of it, make you ineligible for 12 months, and use the other half to pay the nursing home for 12 months. And if we got Medicare coverage for the first 100 days, we could save more than half. It was very effective and it worked fine. It worked like a charm. Unfortunately, not to get political, but under the last administration, the law changed drastically, and now the penalty, this is a little crazy, and you're going to look at me like I got 3 heads, so bear with me. The penalty for nursing home care does not start now until 3 things. A, you have to be in the nursing home. B, you have to be down below the $14,400. And C, you have to file the Ralph Cramden Medicaid application. All right, I don't know if the honeymooners fans here, but the Ralph Cramden application, you have to file an initial application, but you know that I know that you know that I know that it's going to be turned down because you just transferred the money. But you have to file that application to start a penalty running. So what we do now, we have what we call a reverse rule of halves. That same person with $240,000, we will transfer all of it to trusted family member in 2 installments. We'll transfer half of it as a gift and half of it as a loan. That person will sign a promissory note. We'll file it with the application that is denied, but that starts the penalty running. During the next 10 months, we're paying the nursing home out of the loan. The penalty is running on the gift money, and when the penalty is over and the monies have run out, the loan money, we file a second application and Medicaid is approved. That clear? Well, that's ridiculous. When it was first proposed, I was one of those that said, that'll never pass, that's absurd. Well, it did. Right, it's absurd, so I should have known. So that's what we have. But the idea is, like I said, even in that worst case scenario, you could still save half the money. Now, people planning ahead of time may be thinking that, well, let me start moving some assets. The unfortunate part of it now is, whereas before I could say, just because you're getting older doesn't mean you need to start planning. Now you may say, well, I'm 75, I'm 80, I'm in good health, but let me move some assets out of my name to start that 5-year look back. And maybe I'll get lucky and the 5 years will be over and it won't, no penalty will attach, because by the time I need care, if I ever do, that 5 years will be up. All right? And, or maybe I'll only get to 4 years, and I'll pay privately for 1 year, and then I'll apply for Medicaid. So there is some merit to at least giving thought to possible moving of assets. And we'll get into one of the assets that we certainly might look to move because we can still keep control over it, is the home. Now, as far as exceptions, nursing home. New York State is the most liberal state when it comes to husbands and wives, right? This is a great place to be married if you're seriously ill. No, my wife is not here, so I can say that. But this is the best state. We have what's called spousal refusal. Nancy Reagan's phrase, just say no. And what it means is, one of the exceptions to the penalties for transferring assets, if you transfer assets, even in the nursing home, if you're transferring assets to spouse, there is no period of ineligibility, okay? Unlimited transfers from one spouse to another. Also, transfers to a disabled child, no period of ineligibility. So spouse or disabled child. So I will have a spouse come in to see me and say, I wish I had seen you 5 years ago, and that, you know, my husband is in the hospital, they told me he's going to the nursing home, it's long term, and we have, you know, $700,000, what are we gonna do? And I said, simple. We're going to transfer everything from husband and wife to wife, and as part of husband's Medicaid application, wife is going to sign a statement saying that money in my name that you're saying is available to him, I refuse. And the Medicaid will be approved for the institution. Sounds too good to be true, but that's the way it works. Are there problems with it? Yes. It's possible that the local Department of Social Services down the road, after paying privately for a few years, might see wife with, you know, hundreds of thousands of dollars in her name and decide to sue her. They go in cycles. For the last few years, there haven't been any lawsuits. That could change tomorrow. But I tell people, even if you knew you were going to be sued, it's the right thing to do, because the Medicaid rate is about 70% of the private rate, so right off the bat you're saving 30%, and then you make a settlement with them and you're maybe down to 50%, and you've protected, you know, monies that otherwise would have been at risk. So even if you know you're getting sued, it's the right thing to do, and for the most part right now, people haven't been getting sued. About 10 years ago, the Nassau County was being aggressive, but they're not. Yes?
Can't you avoid all that by forming a trust?
Well, that's a good question. I warn people, sometimes when you walk into an attorney's office, you know, you have trust written on your forehead. We make good money setting up trusts. And there are people out there, and I'm going to say this, and most of you are going to shake your head and say, no, that's just not possible. There are some less than honest attorneys out there. It's true. It really is true. There are people out there who send out these flyers, you know, come tonight, free milk and cookies, and learn about revocable trusts. Revocable living trusts, for the most part, are a waste of money. You're going to avoid probate. I have people come in to me and say, I need to avoid probate. I was like, do you know what probate is? No, I don't know it, but I know I need to avoid it. It's like, you know, probate is filing your will with the court. In New York State, in Nassau, in Queens, there's very little simpler than filing your will with the court. They're a terrible story. Oh, it can cost a fortune, it can drag on for years. But, yes, if you're leaving, you know, if you have 3 children and you're leaving one of them 50% and the other 2 25 because you like that one better, and the other 2, you know, think that you have, you know, there's evidence of dementia or undue influence and they're fighting over it, you know, that may drag on. But guess what? If you have a revocable trust and you're leaving an unequal amount, that's going to go into court and drag on. Revocable trusts, for the most part, don't do anything other than line the pockets of the people who set them up. And they make it sound like, oh, this is going to help you with estate taxes. No, it doesn't do anything different than a will does. Oh, you know, there's kind of like that insinuation, oh, you know, it's going to help you with Medicaid. Well, I tell people, revocable trust, you're your own trustee. Somebody else is the alternate trustee when you're dead or disabled, all right? But while you're alive and healthy, you're your own trustee, and you can go and get money, do whatever you want with that money at any time you want. So if you go to Medicaid and say, I've got $14,400, and oh, by the way, my John Bigler revocable trust, John Bigler trustee, has a $500,000 in it, they'll have a good laugh and escort me out of the building. Because that money is still mine. I haven't transferred it. I've avoided having to go through probate on my death, But that's it. And probate is filing your will with the court, and if nobody's fighting over anything, it's gonna sail through in a couple of months and boom, it's done. All right? Revocable trusts, you have to change the title to everything and say, oh, you're gonna save so much money. Yeah, you're gonna spend more money than you would, significantly more than you would to set up a will. You're gonna have to retitle all of your assets, and most people forget, so something still ends up going through probate. When you set up a revocable trust, you always do a oops, I forgot will, in case something didn't go into the trust. It's just, for the most part, if you have property in a lot of different states, or you have absolutely no family, your closest relative is a third cousin in Poland or something, then maybe it makes sense, otherwise it doesn't. But what we do, what we use all the time in elder law, is an irrevocable trust. Irrevocable trusts do protect for Medicaid purposes, but there are limitations. Somebody else has to be the trustee. You can't be your own trustee. And the trustee cannot invade the principal of the trust on your behalf, okay? Whatever you put in the trust, they can't go in there and give you the money. You get the income generated by the principal, but not the principal itself. So, we are never like revocable. We're never putting all of your assets in. One of the things we may say is like, someone comes into me and they're in good health, they'll have $500,000 in liquid assets and $500,000 house. And I may say, you know what, let's put the house in an irrevocable trust and leave the money out. And if something terrible happens and you need to go to a nursing home, and most of us aren't going to have long-term nursing home situations, that's just the reality, no matter what the insurance guys say. Maybe you'll spend half of the 500, so we protected 750. And the thing is, by putting a house in an irrevocable trust, yeah, you can't get money from it, but it's your house. And you still have a certain degree of control over the trust. And you say, well, wow, if somebody else is the trustee and they can't give me the principal, that doesn't sound very good. But you can fire the trustee at any time without any cause. And you can check, you name beneficiaries. When the trust terminates, when you die, there are beneficiaries. You can change those beneficiaries amongst family members, identity, percentage-wise, and so forth. So I always like to use an outrageous example, but people get a kick out of it. Husband and wife come in to be at 80 years old, both in good health, and they move their house into the irrevocable trust. 10 years goes by, husband passes away, wife is 90 years old, she's fine. Mentally, she's fine. They had 3 daughters, A, B, and C, and A is the trustee, and all 3 daughters get a third at the end. My wife comes into me and she says, I've just met 25-year-old surfer boy, and I'm in love. Okay. See? And I want to sell my house, and I want the trustee to sell my house, and I want her to buy a co-op near the water in Long Beach, because surfer boy needs to be near the water, right? And daughter A says, Ma, that's disgusting. That's just revolting. I'm not doing that. You're crazy. I'm not doing it. But Mom isn't crazy. She's in love, okay? And so she says, okay, daughter A, number 1, you're fired. And number 2, instead of getting a third, you're getting a 5%. How do you like that? And daughter A thinks about it and says, I could use some surfing lessons myself. Okay, Mom, I'll do what you want. So Mom still, you have this club that you still have control over the trust. Now, if in fact Mom is suffering from dementia and 25-year-old is taking advantage of her, then the trustee, that's her job, is to step in and stop that from happening and present evidence of Mom's medical condition, and she can do that. But assuming, Mom is fine, then she still is in, Mom or Dad, I can switch it around, he can be with 25-year-old surfer girl. But the idea is that the grantors still have control. Yes?
What if Mom is the trustee?
Can't be. In an irrevocable trust, in order for that trust, in order for the assets, I'm sorry?
It's irrevocable?
Yeah.
Irrevocable.
And a revocable is?
Revocable is basically worthless. It's a waste of money. And again, I've had people say, oh, I went to the seminar and they wouldn't let me leave until I signed up for an appointment at the lawyer's office. I'm like, do they have like armed guards there? How did that happen? But you just got to be careful when you'll see these things. They're pink or yellow flyers. You come next week and hear about the glories of revocable trust, and it's nonsense. But irrevocable trust can be an effective tool. But the thing that we use it for most often is the house, and sometimes stocks. The beauty of the trust, one of the things people do, they panic, and you'll hear with elder law, oh, elder law, yeah, you need to run around like a chicken with no head, and it's probably too late, and you can't do anything, and it's, it's like it's too late for it. And that's not the way it works. You need to think about it, and you have a consult with an elder law attorney, and you go home and you ponder it and you kick it around and you call the lawyer and you discuss it, and then you make a decision. All right? But sometimes people just go ahead and transfer the deed to the house. I got to get out of my name. I got to avoid that lien. So what happens? You bought the house for $25,000. Now it's worth $525,000. You just give it to your children. They're getting it at $25,000 for capital gains purposes. Your real estate taxes immediately double because whatever senior benefits, veteran benefits you've lost because you're not the owner anymore. It's and you have no protection. So I say, my daughter is an angel, but what if she marries the bum?
Yeah.
And then the bum says, hey, let's go take a mortgage out on the property, and I got this business, neon pizza that can't fail. The next thing you know, I'm out in the street. So you want to have control. Now the simple way to do it, and there is a simpler way than the trust, you could just transfer the property and keep a life estate, the exclusive occupancy of the home for the rest of your life. That doesn't give quite the flexibility to sell it in the future, and now more and more, because assisted livings, you may want to sell the home and need that money to pay for assisted living. So life estate is a one possibility, or an irrevocable trust, but there are ways to consider protecting the house and yet still keeping control. Now, there are a couple of people you can transfer the home to, and there is no period of ineligibility even in the nursing home. And in those situations, you may forego the trust because there's a 5-year look back and period of ineligibility, and transfer it outright but keep a life estate. You can always transfer the home to your spouse, to your minor or disabled child, to a brother or sister who has some interest in the home, like 2 sisters who have the home in both names, all right? That sort of thing. One can transfer the other, no penalty. Or the last one, which is the one we use the most, transfer to an adult child who's lived in the home for at least 2 years and is presumed to be taking care of you, all right? I just had one last night, and I tell people, it's like there's no urgency. You always have that person, that child as a fallback, as a safety valve. Now, there's a presumption they're taking care of you. I tell people, I have an adult child living in my home, and I'm taking care of her. She won't leave. And that's fine. I love her, and it's great. Now her boyfriend is there, I'm taking care of him. But anyway. The idea is there's a presumption that she is taking care of me. If something were to happen to me and I needed nursing home care, then I could transfer the home to her and there would be no period of ineligibility. And in that situation, we'll forego the benefits of the trust and I would transfer it to her and I would keep a life estate, the exclusive occupancy of the home. So I would still keep, if I had any real estate discounts, I would keep those because I have the life estate, yes.
Suppose you transfer to a child, a child, whatever age, who's been living in the house forever, but there's a brother. So doesn't that complicate things? And what if you have a trust, a bypass trust, where the 2 sons are the beneficiaries and the executors, I guess both? Isn't there a problem with the second son then?
I mean, that's something that has to be dealt with. And again, I had it last night. And one of the things that I ask people right off the bat when they come in the office is, what's the family situation? If there are problems, if there are people that aren't talking to each other, we're very limited in what we can do. But if everybody is on the same page, then I would say, well, let's do 2 deeds. We're going to transfer the house from a parent to child who lives there, and then that's all Medicaid is looking at. And then that child is going to do a second deed, transferring the house from themselves, from themselves to themselves and their siblings.
Permitted to do that?
Yeah, now, you're gonna get, there are people who are like hysterical, but, oh no, that's fraud, you can't do that, but that's nonsense. You know, the law is very clear. Transfer to the adult child who lives there is exempt. Whatever that child does has nothing to do with anything. So if they want to turn around and make a second transfer, they will. And I'll often say, maybe we'll do both deeds at the same point if the other child is nervous. And we'll just wait a week to file the second one, so there's no confusion. But we've done it over and over again, it's never been a problem.
Oh, you're talking about homes that are houses. What do you do with co-ops and
Co-op that's a good question. Co-op is the 4-letter word in elder law planning. Because, there's a good thing about co-op, they look over everything and they make sure that everybody is, desirable and so forth. But the problem with the co-op is that you can't just do what you want. You have to get the board's approval. And so we are limited. At best, we can set up the irrevocable trust. There's no transfer of the share with the life estate, that doesn't exist. If the board allows it, we can do a transfer of the co-op shares into the irrevocable trust.
Q? I did that.
You did that? Yeah. Now, I tell people, very modestly, 99% of my clients love me. Okay, I can say that without. But the few that don't are the ones that I told them in the beginning, this co-op problem, we're going to look to transfer it into the trust, but you got to understand, number one, the co-op board doesn't move very quickly. So instead of a 5-year period, you might have a 6-year period while they're dilly-dallying. And they're going to have their own fees. They're going to have a fee for their attorney to look over the trust that I drew up. They're going to have a fee for a new share. They're going to have a closing cost. I may have to go and sit in the boiler room of the apartment building with the lawyer for the co-op. They got all sorts of things. And sometimes the co-op board just says, no, we're not letting you do it, and then you're stuck. It happens less now.
But how does that balance into the Medicaid?
Well, what will happen is, once the trust is set up, that starts a 5-year period of ineligibility for nursing home care. So if it's already been done, that period is running, and then you just need to stay out of the nursing home.
My guess?
But that's the tool.
Can I look at it?
Absolutely.
But that's the tool, the irrevocable trust for co-ops. We don't have the option of life estate or trust. If anything, it's the trust. And then we hope for the cooperation from the co-op board, yes.
I'm getting very confused.
I do that.
If you have long-term insurance,
You can avoid a lot of this.
so the Medicaid portion of your talk doesn't refer to somebody that has long-term insurance.
Assuming that you have very good long-term insurance, hopefully, then you don't have to be concerned like other people do with moving assets out of your name. That's the beauty of the insurance, that it allows you that peace of mind and that control to say, I don't have to be bothered with guys like this. You just have to be bothered with the insurance guys. But if you have a good insurance guy, then, and you have a policy. He died? Well, that might be the best time.
No way.
Yeah.
How do they treat IRAs?
IRAs, if they're in payment status, and if they're over 70 and a half, are exempt for Medicaid purposes. So you can have, now they'll look at the income, right? So if you have $1 million IRA and you're getting, 1,000, but like I have a guy right now who has about $1 million in IRAs, but he is on a respirator. And so the nursing home cost, even though, his IRA is generating like $15,000 a month, the cost of the nursing home is more than $30,000 a month. So we're applying for Medicaid for him. And they will take the income
15.
and apply it to, but the principal stays where it is until his passing and then goes to beneficiary.
Then it goes to the.
Yes.
So the principal, and in effect, the principal of that IRA is protected.
Yes. Yeah, which is good, because the last thing we want to do is start telling people you shouldn't cash in your IRA. Because, you know, you don't know, most of us aren't going to nursing home. We're all paying taxes. And you're cashing in an IRA all at one time, it's a disaster. Yes.
What about a tax deferred annuity?
If it's in payment status, same thing, exempt. You know, and protected. All right, let's see. Oh, I handed out, besides the other, I handed two very important documents. Am I okay with the time?
Fine.
Okay.
Is everyone okay with the time? Are you
Yes.
getting antsy, or this is fine? Everyone has a healthcare proxy?
Yeah.
And you have a power of attorney.
I don't think we had enough power of attorney yet.
Oh, I have more.
Okay, good. Very good.
I have a health.
Okay, who needs a power of attorney like this?
I think I'm videotaping my stomach.
No, but I'll look at the camera and say.
If it's wrong by now, it's too late.
The form for the power of attorney, but it's not this.
That is that's a draft of a power of attorney.
Do you have to draw one up?
Yes. I specifically put draft on it.
Good.
Oh, it looks good.
Yeah, it looks good.
He's gonna be proud of us. Two documents. One of them, you need assistance